to come before the court is State versus Smith. And I know both sides are here. We're about 5 minutes early. Is there any reason we can't proceed? Is anybody expecting anybody to be in attendance?
Fine with us.
All right. You both know, since you've argued here many times, that you have 15 minutes as the opponents. You can reserve up to 5 minutes. Please keep your voice up, introduce yourself, stand behind the podium. We are recording, so please do not mention any minors' names or any victims' names. And just let me know how much time you want to.
Good morning, Your Honors. If it pleases the court, I'd like to reserve 5.
Thank you.
My name is Mark Ludwig. I have the privilege of being appointed by this court to represent Mr. Smith, initially on a motion to dismiss filed by the state. All my work and research on that issue resulted in not discovering the 2 cases that this court cited in a 1-page order that allowed this case to proceed. I hope my research has been better. The standards of review in this case are plain error and abuse of discretion, and frankly, I was very happy to see Adams decided. If I had to listen to Bob and Rita Blakemore one more time about what abuse of discretion was in a criminal case. In terms of the error in opposing sentence, I mentioned, and it was not in my Rule 21 citations, I noticed that this morning the United States Supreme Court is hearing arguments in Ramey, which is the 5th Circuit case. They're hearing that today. That's going to be an interesting decision, which might have some impact here, it may not. I want to emphasize, I'm urging this court to use the Ohio constitutional standards. I'm not here arguing they're necessarily greater than the federal standards, but this is an Ohio constitutional case. I'm very tired of the federal courts telling us what our Constitution protects. In terms of the new counsel assignment of error, the Harris standards that cited in our brief and in the Rule 21s are pretty clear. In terms of denial of a new counsel, the question is, was the motion timely? This one was. The second part is, did the trial court adequately inquire? If this court believes that the transcript shows an adequate inquiry, I would take exception. Third standard is, was the extent of the conflict so great it resulted in a total lack of communication? Well, look what happened here. There's a CCV hearing set, and his new counsel is appointed for that hearing. The hearing doesn't go forward as scheduled. In fact, he's not even in the courtroom when it's continued. So between the new appointment of CCV counsel and the hearing at which he said, I want a new counsel, there was no activity. And CCV trial counsel, I have the greatest respect for Doc Walker. Doc can stand in that system and put up with it every day. I have the greatest respect for him. But Doc didn't say, I've had enough time. Doc didn't say, I've seen him 3 or 4 times since I've been appointed. This record reflects that he got a new counsel. The next hearing he wasn't even at, and then he shows up for a hearing on CCV. In terms of the effective assistance of Doc, again, I can't criticize Doc Walker for anything. But the state does say, gee, he was effective because he conducted a direct exam of the defendant. Would you look at the context of how that direct exam came about? The state presents its case. Doc ably cross-examines as best he can, and then says, well, we're going to rest. Oops, wait a minute. My guy wants to testify. And he does then testify. How much preparation is reflected in that. When the lawyer admits he was not going to call the witness, and then the witness behaves as only Mr. Smith could behave. I think an interesting thing about Mr. Smith that I've learned, and I hope the court notes this, this is an intelligent young man who's really willing to work hard. It's such a waste when you look at all the work he's willing to put into things. It's such a waste that he's where he is for this case. And I want to emphasize, accepting the proposition of the application, the erroneous application of sentencing in this case, given the development of constitutional law, accepting that works no great harm and in fact aids substantially the body of the law in this case. I don't
know what's going on with that. You're at 9 minutes and you have 9 minutes left.
Okay. Your Honor, if it please the court, the denial of due course, the fourth assignment of error, my argument's pretty vague. I agree to that. But one of the reasons that it's a little vague is because that man over there, Sam Bell, and that's why I cite the case. In Rose, I'm a solicitor trying to defend Mayor's Court. And Sam says to me, Mark, it's how it looks. It's not how it really is. If this court tells me that this trial court judge conducted herself in a class due course of law way, saying things like, we're going forward, you can appeal when we get there. When we get there, there's automatically going to have to be an appeal.
Well, this was a very unfortunate situation with your client, right? Because he kept talking over the judge, he kept talking over everybody. This was his fourth attorney. And then he hadn't appeared, had been, AWOL for a while. So it wasn't like he was the easiest person to deal with. Now, that doesn't mean that a judge doesn't have the responsibility to still make sure due process rights are protected. But you can't just look at it in a vacuum, can we?
Well, I think the vacuum also concedes 3 other attorneys who the trial court agreed should be removed. So when we say there's 100 or there's 4, the trial court never disagreed before that those first 3 weren't doing their job.
Well, some of them withdrew, did they not?
Pardon?
Some of those attorneys withdrew, they weren't removed.
Oh, no, I wasn't saying they were removed, Your Honor, but some of those...
Okay, you just were implying to me that the trial court decided to remove
I'm
them.
very sorry, I was not
I
trying to...
want to make sure I understand the record.
No, the issue was considered on motion to withdraw by all of them.
Okay, let me ask you on your due process claim, because you're right, it was vague. Are you only arguing that the process violation, what Judge Croce was somewhat biased and not anything else in the process of this hearing? In other words, your client got notice of the charges prior to the hearing, he knew what they were, he had an opportunity as far as that went to understand what he was being accused of doing.
But for the denial of counsel,
Okay.
which, all of that being considered, Your Honor, it's not the cancer that killed us, it's the treatment.
Well, I want to make sure I understand, since your assignment was vague, exactly what you're saying in the due process.
And I've often been obtuse, Your Honor, probably since I started standing here. It's interesting, the recommendation of the probation department was, we recommend you reimpose the original sentence. Well, the original sentence was probation. And the entry reflects that any imprisonment was withheld pending further proceedings. So when this hearing comes up and the PO recommends reimpose the, quote, original sentence, we're all not talking about reading the entry and seeing what the original sentence really was. I'm not trying to create bad precedent that ruins these kinds of hearings forever. This is an as-applied situation to very limited facts, as Judge Carr pointed out. My client is not totally innocent. I thank the court for its time.
May it please the court, Heaven DiMartino on behalf of the appellee of the state of Ohio. We are asking that this court affirm the decision of the trial court finding that Mr. Smith violated the terms and conditions of his community control and imposing a 36-month prison term. With regard to the first assignment of error, the state would argue that the trial court did not commit plain error in finding that this defendant had violated the terms and conditions of his community control. The argument seems to be that the defense is arguing that under Bruin, which was decided in 2022, his weapons under disability charge, which he pled to and had a final appealable order well before Bruin came out, and the predicate offense, which was trafficking in marijuana, which he also pled guilty to years before Bruin came out, somehow negate his weapon under disability conviction for which he was on probation. However, Bruin was not a decision that held that weapons under disability is now a void conviction, or that it's voidable, and certainly there's no procedural basis for the defendant to be challenging those prior final appealable orders here within the context of a conviction on a community control violation. With regard to the second assignment of error, which is probably the one that bleeds into the other assignments of error, the trial court in this case did not abuse its discretion in denying the request for new counsel. First, when you read the transcript, he did not ask for a new attorney. He said he would like to fire his attorney. The court replied to that by saying, "This is your fourth attorney." It's important to take it within context that the probation violation was initially filed, the notice, November 23rd, 2021.
Did the trial court allow him to talk about why he didn't want that particular attorney, or was he silenced at that moment?
The court told him to stop talking, but he did continue to talk. And he did get into the reasons that he wanted to fire the attorney, which included he didn't get me everything I needed. He didn't prepare me. So he kind of continued to talk over the judge. So while I think what you're asking me is, did the court stop and say, "Mr. Smith, tell me more about that"? That did not happen.
It was not explored, there wasn't a colloquy about it.
There wasn't a colloquy as far as the question and answer. However, the defendant has the burden, before the court has a duty to inquire, to articulate specific reasons for wanting to have an attorney, which he did not do there. He just said, "I want to fire this attorney for ineffective assistance," without getting into more. And he did have time to talk because he just continued to do so. The reasons that he gave were not adequate, they weren't specific, and contrary to what opposing counsel argued, the record does show that Attorney Walker, the fourth attorney, did have conversations with the defendant, because he says the attorney didn't get him everything. He doesn't say he got me nothing. It's clear that Mr. Smith was a difficult client for at least 3 other attorneys. They all asked to withdraw, and they were given permission to withdraw due to conflicts. This attorney did not ask to withdraw. Attorney Walker was prepared to go forward. While he did not interject when the client talked about, "I want to fire him for ineffective assistance," it wouldn't have been appropriate either for Attorney Walker to have a conversation at that point. If the court had asked Attorney Walker, "Are you prepared to go forward?" he certainly could have done that. But he didn't say he wasn't prepared. And when you look at the violations in this case also, with all due respect, it didn't take much preparation to be able to handle this particular probation violation hearing, because he had new charges. So even if you take out the defendant's argument about why he missed all of his requirements to report that he missed, he had an excuse for every day, and why the possession, the positive marijuana charge should be okay, which was because he was in the process of getting his marijuana card. Even if you take all those violations out, the fact of the matter is he came into court for the prior probation violation hearing and then left, which is a violation of his community control. He has 2 new charges that he was facing at the time. Those are violations of his community control. But getting back to the request for another attorney, the state would argue first that the defendant has a duty to articulate specific basis for wanting his attorney to be removed before the court has an obligation to inquire further. When you look at this entire record, you can tell over 10 months and 4 attorneys, the judge was very familiar with Mr. Smith and the fact that he had missed court appearances, that he had.
Shouldn't we be basing it on the individual attorney? You can have 3 prior attorneys and they've left for some reason
Absolutely.
unrelated. Shouldn't the court be at least allowing the defendant to speak about why he might want a different attorney?
If he had said more than I want to fire him for ineffective assistance, yes. And while the better practice may have been to ask a few questions, the defendant did get the opportunity by interjecting to set forth what his reasons were, and they were not specific. And even if you apply the test that opposing counsel cites Deaerre and Harris, which was from the Supreme Court in Jones, which was a case where a defense counsel wanted to withdraw, the timeliness of the motion, the state would argue that this was not timely. It was raised, not in writing, orally, at the hearing, not before. There is nothing in the record to support that this defendant was not aware of the date of the probation violation hearing. It is true that he was in the jail and he wasn't present when the case got called, but there's nothing in the record to show that he didn't know he was coming in that day for the hearing, including his own words. The adequacy of the trial court's inquiry into the matter, because this attorney did not ask to withdraw, and because the defendant did not articulate any specific reasons, and within the context of the 10 months and 4 attorneys that had been on this case, the state would argue that the inquiry was adequate. The extent of the conflict between the attorney and the client was so great that it resulted in a total lack of communication, preventing an adequate defense is the third prong of that test. There's no evidence here that the attorney and the client had any type of adverse relationship.
But if it's not explored, how would we ever have evidence of that?
You can tell by the conduct of the hearing. And there was and to the point that he makes that defense counsel said, I have no witnesses, and then he said he wants to testify. That is something that can happen all of the time when you have a client who you're advising not to testify, let's say, and you believe he's agreed to that, and then suddenly they change their mind. But there was nothing in the record, certainly Attorney Walker could put that on the record to say, actually, we are not communicating, there is a breakdown in our communication. He did not do that. And the balancing factors for the public's interest in a prompt and efficient administration of justice, as I noted earlier, it took 10 months for this community control violation to come to hearing. And that was in great part due to the fact that these attorneys and the client had conflicts. Not saying that it was all the client's issue, but clearly there were issues going on that took that long for this to come to the point where there was a hearing, and this defendant was continuing to violate the terms and conditions of community control, including committing new offenses. And the public does have an interest for prompt and efficient justice in this case when someone who's on community control is abusing that privilege and continuing to commit additional crimes. In this case, the defendant was not denied effective assistance of counsel. When you look at the hearing transcript, Attorney Walker gave an opening remark. He talked about what he felt was the significance of the violations and what he thought the results should be. He cross-examined the probation officer. He got into whether or not there was mental health treatment available for the client. Those were things that he must have had some preparation to be able to do that, to understand that his client had some issues with regard to that. He did call the defendant to testify when the defendant indicated that he wanted to testify. He did that direct. With regard to what the due process requirements are, as the judge asked, he was given a written notice. He was told of the evidence. He had the opportunity to be heard, to present evidence, to confront witnesses, to cross-examine. He had a detached and neutral hearing body, and he was given a written statement of why his community control was revoked. Just because the judge said, we will get to it, when we get to it, basically, that is just the judge indicating the process. An appeal has to happen after there's a finding that this defendant violated the terms and conditions of community control, not before. That was not the court indicating that she had a predisposition into the matter. The hearing transcript shows that probation officer was asked all of the questions that would need to be asked to show that there was a probation violation, starting with, was this person, under your supervision? Did you go over the rules? What were those rules? Did he understand those rules? And then, why was he violated? And also, by the way, why was there an addendum to the probation violation? Because even after he was served the notice of the violation, he continued to fail to report and to get positive drug tests, and then to leave court when he had a community control violation hearing. So with regard to those facts and the evidence that's in the record, the state would argue that the trial court in this case did not abuse its discretion in denying Mr. Smith's request to fire his attorney, that he did in fact have effective assistance of counsel, that due process was complied with, and that it was not plain error to find the defendant guilty of the community control violation and to impose the sentence that had previously been suspended. And no other questions, I rest my brief.
Thank you. You have your 5 minutes remaining, Mr. Fleming.
Thank you, Your Honor. If it please the court, I did say in my opening argument, and I don't hear it rebutted, that it's obvious that this client was not prepared to testify. It's in the record. Doc says, here's my cross-examination, I rest. Oops, my guy wants to testify. Now, if he didn't know his guy wanted to testify at that point, he didn't prep him to testify.
Except that we know there might have been a change of mind. That the defendant might have changed his mind and said, I'm insisting on testifying.
But, Your Honor, there's no indication in the record that the defense lawyer and the client talked at all.
Why that be the key point? There's no indication in the record, one way or the other. We don't know from the record if he planned to call him, didn't plan to call him. This is all speculation.
Oh,
That's what
no,
was going on.
it's not speculation, Your Honor. If you want to rule that way, I'm comfortable with you, but it's not speculation. It's the pragmatic experience of what goes on in that courtroom every day.
But it is on the record that the client was via Zoom and Donald Walker was in person, correct? Or were they both via Zoom?
I don't recall whether they were in person or Zoom. I believe they're always in person with Judge Croce, but I don't know how it makes any difference.
Because I think logistically, how do you talk if one person's on Zoom and one's attorney's at the hearing?
Your Honor, I managed to interrupt in any format, so I don't know.
Well, I'll double check that, because I thought that I read that one person, that he was at the CCD hearing via Zoom from the.
Well, and again, I'm not knocking Doc. I don't see it that way. I'll finish with this again. If this court tells me that this is a record of which we should be proud for any reason, I'll listen. Thank you, Your Honors.
Thank you. Thank you both for the presentations. The court will take the matter under advisement, and a written opinion will be sent to both sides. And also, please look on the Ohio Supreme Court website for